Good afternoon. As time is short, we'd like to start straight away. During much of the forum, there's been mention of international law, international courts. And I think there's a lot of misunderstanding as to what they can do, and particularly misunderstanding of how important the rule of law is, and how important it is that the institutions that support the rule of law operate and are strengthened. And what we're going to do is have a look at the two principal institutions, the International Criminal Court and the International Court of Justice, and then look at what they're doing and how what they're doing can be better. And we should particularly look at the issue of enforcement. So what I thought we'd do first of all is just lay the groundwork by saying a little bit, by asking the panelists to say a little bit about each of the courts, because I think sometimes it transpires that not enough is understood. And I want to begin with the International Criminal Court with Adrian, who was a judge there. Adrian, can you just explain really what does it do and how does it get its jurisdiction? And then I'll ask another to elaborate a bit on that. Adrian.
So what gives the court power, and power over what? I want to stress, however, at the outset, what a perilous time this particular moment is for the ICC. There are indications, some would say clear indications, that come January of next year, considerable pressure will be brought to bear on member states to pull back in their support for the court. I'll return to this issue in a moment in a different context. But when nations are forced to choose between tariffs and sanctions on the one hand, or distancing themselves from the ICC on the other, I fear that the latter option may prove to be the course that is followed. The augurs do not look good. But returning to the question, power over what, first of all? 4 crimes: war crimes, genocide, crimes against humanity, and aggression. Aggression came late in the day in 2017. The annexation of Crimea is a classic example of what that crime is meant to cover. I believe that a 5th ecocide stands a reasonably good chance of being added at some stage in the not too distant future. That proposal is advanced by Fiji, Samoa, and others. Belgium has recognized it as a crime, and the European Council and the European Parliament have both equally recognized it. What about the exercise of power? The court exercises its powers in 3 ways. Security Council referrals is the first. This, historically, is not something to be written off. The UN Security Council referred Darfur to the ICC in 2005, and then Libya in 2011. The critical factor here is that the United States abstained as regards Darfur, but voted for the Libyan referral, which was unanimous. The United States has remained solid in its support for the ICC and its work in Libya, consistently with its really impressive support for the ad hoc tribunals of yesteryear. Secondly, member states can refer a situation to the court if crimes have occurred allegedly. And third, the prosecutor can initiate investigations. I want to spend just a second on numbers because they are incredibly important. It is right, and it is so understandable, that there has been criticism of the court for focusing on Africa. But the hard reality is that situations were referred by states to the ICC, by the DRC, by Uganda, by the Central African Republic twice, and by Mali. In fact, there have only been 3 countries where the ICC has acted on its own powers of investigations. The breadth now of the cases span Ukraine, Venezuela, the Philippines, Afghanistan, Bangladesh, and Georgia, along with Palestine. And of course, it is the investigation in Palestine that has created the present extremely perilous position for the ICC. Three final things. First, the American Congress in August of 2002 passed what has been called the Hague Invasion Act. No doubt this was principally aimed at being able to remove American personnel should they end up in the cells in The Hague as a result of allegations of war crimes. However, it also gave protection to covered Allied personnel, which would include, beyond any doubt, Prime Minister Netanyahu and Mr. Gallant. So in 2002, we thought it was highly unlikely that there would ever be resort to the use of that piece of legislation. But should either of those gentlemen be arrested, I would hope that we're not going to be seeing one NATO member invading another. Second, the court has jurisdiction over heads of state. That was resolved by the appeals chamber in the al-Bashir case on the 6th of May 2019, and Article 27 of the statute is glitteringly unambiguous on that issue. And third, the fact that Israel has not accepted the court's jurisdiction is irrelevant because the state of Palestine acceded to the Rome Statute in 2015, and subsequently the situation in Palestine has been referred to the court. That, I hope, was a quick review of at least the main issues in relation to jurisdiction.
Now, before we turn to the International Court of Justice, I just wanted to ask Victoria, a former Attorney General, that's active in one aspect of looking at war crimes at the moment, to add her views to the way the jurisdiction works.
Yes, well, Adrian's given, in fact, I thought, a very comprehensive summary of what the ICC does. So I think it leaves me just to explain why I think all of us here feel it's important that it does what it does. I'm very involved at the moment in helping Ukrainian lawyers prosecute some of the war crimes that have taken place in Ukraine over the last nearly 3 years now. And it's been interesting watching them as they come to a full understanding of what has happened in their country, how they're going to sort it out legally, and where international law fits into that discussion. So it's important to remember that most war crimes, of course, will be tried domestically, and they are in Ukraine trying war crimes domestically right now. I think they've tried. At the last time I looked, there were about 93 cases that have been tried to a conclusion, and they have, I think, around 130,000 open case files of war crimes, nearly all of which will take place in Ukrainian courts with Ukrainian judges, with Ukrainian lawyers. They are extremely keen to make clear whenever you talk to them that they will make sure that those accused of war crimes have proper defences, and they have left open, they've had some very technical discussions about the incorporation of the Rome Statute into Ukrainian law. It comes into force next month. About the way in which Ukrainians may well need to be tried for war crimes, but that is going to be left until after the conclusion of the conflict. It is unusual for so much activity to be taking place in the courts during the course of a conflict, but I suspect it's the way that we will be going from now on. So all of this work has led me to think hard about the complementarity of the ICC and how that works in the modern world. The ICC, it's very clear, can only step in when there is no active, and there's a lot of judicial discussion about what active means, investigation and potential prosecution going on in the home country, the place where the crimes are alleged to have been committed. And it's clear that the person accused and the crimes for which they're accused really have to be the same as that investigation And then the ICC, if the ICC has confidence in what is going on, will not get involved. I think that's right, but it is clear that the series of conflicts that are going on at the moment is testing that principle to the utmost. And it's going to be interesting to see how that plays out. There's also a secondary worry about, well, I don't know if it is a worry, it's not from an English law perspective. A second point to note about the ICC's jurisdiction: clearly, people can't be tried there unless they're present in court. You can't try in absentia. Under both the Russian constitution and the Ukrainian constitution, it's perfectly normal to try in absentia. They are working very hard to make sure that they can prove that papers are properly served on the defendant, but it's then proper to proceed in Ukrainian law. And I think that will be the subject of a certain amount of discussion in the coming years as well.
Well, thank you very much. Can I now turn to look at the non-criminal aspects of it and the jurisdiction of the International Court of Justice? And I was going to ask one of its leading practitioners before the court, who's been involved in a number of the cases, Brynne, to say a little bit about the contentious jurisdiction before we turn to look at the advisory jurisdiction.
So the International Court of Justice is a much older beast than the International Criminal Court. It's often confused with it because it's confusingly sits in The Hague also, although in much more salubrious surroundings of the Peace Palace. And it's also sometimes confused just because there is a jurisdictional overlap. Just as Adrian said, the International Criminal Court deals with crimes against humanity and genocide. So too can the International Court of Justice. But whereas the International Criminal Court is focused on criminal responsibility of individuals, in terms of its contentious jurisdiction, the ICJ is concerned about disputes between states. So in terms of its contentious jurisdiction, only states have access to the court. Individuals and international organizations cannot. Now, states can take up the cause of individual nationals if they so choose, and there are some very famous cases where they have done this. For example, in the Legrand case, where Germany sought to prevent the execution of a number of its nationals by the United States, or indeed, perhaps more relevantly to the ICC's jurisdiction, where the Democratic Republic of Congo sought to stop the prosecution by Belgian domestic courts of its serving foreign minister. But in those cases, it is a dispute between states. It is the state that's taking up the dispute on the part of its citizen. Now, because states are sovereign and can decide for themselves how to resolve disputes before them, the International Court of Justice can only act where states have conferred jurisdiction on it. And there are three key ways in which states can confer jurisdiction. One is where a dispute has arisen between two or more states. They can decide, subject to an agreement, to refer that particular dispute to the court. That's the most restrictive form of jurisdiction on behalf of the court, and it's called the jurisdiction by special agreement. Secondly, treaties can confer jurisdiction on the court. They can be bilateral treaties or multilateral treaties, like the Genocide Convention, which we've seen being litigated in a number of cases before the ICJ. But so where treaties have what's called a jurisdictional clause, that means that any disputes concerning the treaty, its interpretation or its breach, can be submitted to the ICJ as between the parties to the treaty. And like I say, that bilateral treaties, so one of the cases I was involved in, the then Republic of Macedonia against Greece, that was a bilateral treaty, a dispute that arose between the two parties. But in other cases, such as, for example, the example I gave of the Genocide Convention, it's a multilateral treaty. States can submit reservations to treaties that will qualify their submission to jurisdiction in relation to disputes. But that's broadly speaking, as I say, the second form of jurisdiction is subject to treaties. And there are about, I think, 300 treaties that have these jurisdictional clauses. The third and broadest form of jurisdiction is what's called the compulsory jurisdiction, often also called the optional clause scheme. And that's where states in advance agree to submit any dispute concerning international law or any dispute of an international nature to the International Court of Justice in relation to other states who have similarly accepted the jurisdiction of the court. And there again, there can be reservations. They can be reservations in terms of temporal scope. So since the Chagos litigation, the United Kingdom, for example, has inserted a clause that requires 6 months' notice before a state can submit a dispute against it, no doubt to give it the option to withdraw its agreement should it so choose. My own country, Ireland, has a particular reservation in relation to any disputes with the United Kingdom relating to the north of Ireland. So there's ways in which it can be restricted, but broadly speaking, the court is given broad jurisdiction. Now, that doesn't mean, and I'll just include on that once the states get before the court, they then agree that there is jurisdiction, and there is an increasing development in international law cases where the first thing to be disputed or the first thing that's raised in a dispute before the ICJ is whether or not the court does in fact have jurisdiction. And states will dispute that there is in fact a dispute with the other state, whether it has been crystallized, whether they've been notified, whether the other party is a proper party to the dispute, etc. But that, I hope, is a broad whirlwind overview of contentious jurisdiction before the ICJ.
Can we now then turn to the last bit of background briefly about the advisory jurisdiction of the International Court of Justice? And for that, I'm going to ask Sien He, who's a distinguished jurist, an academic writer whose writings are much taken into account, to explain that part of it. Having laid this groundwork, we'll then go on to some of the contentious issues.
Thank you, John. It has been mentioned that the International Court of Justice is older, but the spotlight nowadays seems to be on the ICC. I would like to let you know that it's not just the ICJ is older, but the ICJ is more important. Why? Because it is designated as the principal judicial organ of the United Nations in the charter. Okay. This importance or this principal judicial organ nature of this court has been described as being the most important settler of disputes between among states. As a matter of contentious jurisdiction, right? It's also very important for this court to participate in the work of the UN system. And this comes as a result of the advisory opinion jurisdiction that the charter has given to the court. For those who have been reading, legal instruments, you may see that in Article 65, the statute, it said that the court can give advisory opinion, to any organ that has been authorized by the United Nations Charter or in accordance with it to request an opinion. Okay, it's simple and elegant, and the work that the court has been doing is basically part of the participation in the work of the United Nations system, and we can see that very important questions have been presented to the court through this route: decolonization, the legality of prolonged occupation, climate change, right? Or what we would say, or what we consider to be the big cases, big matters, big disputes, or big questions will be presented to the court through this route. Recently, I think there may have been some concerns about how advisory jurisdiction may cut into or detract from the principle of state consent, which is altogether another question that had to be dealt with on another occasion. I think I will just give you this brief introduction, and I will be happy to answer questions later on. Thank you.
Thank you very much. I hope from that it's clear that there are very definite rules and that these are critical institutions to maintaining the rule of law. What I want to now turn to is the views of those on the panel about how effective it can be, how important it can be. And can I begin first with Adrian and ask him this question? It's possible to be very negative about the International Criminal Court, but looking at your considerable experience of it, can you see it really making a difference to the way the rule of law is upheld internationally?
Well, there's obviously no empirical verification that can be obtained of this. But generally speaking, from a common sense point of view, I don't think anybody particularly likes being arrested, prosecuted, and imprisoned. And situations change. Hosni Mubarak of Egypt, Saddam Hussein of Iraq, and Nicolae Ceausescu of Romania probably never dreamt that they would end up being arrested, charged, and prosecuted. The past can catch up with you wholly unexpectedly, and I think there is increasing realization that this is the case. But one can approach this as well, somewhat indirectly, but I think in a profoundly important way. Every United Kingdom commander deployed on operations must have access to legal advice, and that position is replicated in many other countries. This has emerged because soldiers are accountable and they need to act lawfully and they need to know that they are acting lawfully. I think that this is a potent sign that the possibility of court sanction has bitten deep. And it's demonstrated by some of the steps that have been taken in recent years in relation to alleged military outrages. For instance, in only March this year, 5 special services soldiers were arrested in the United Kingdom, suspected of war crimes in Syria. The independent inquiry in the United Kingdom in relation to Afghanistan is mandated to investigate and report on alleged unlawful activity by United Kingdom special forces in their conduct of what has been called deliberate detention operations in between 2010 and 2013. Not to put too fine a point on it, the allegation is one of extrajudicial killings. This only occurred because legal proceedings were brought in the courts of the United Kingdom, which led to those cases being effectively adjourned and a public inquiry set up instead. Therefore, if you transgress, there is a growing realization that justice has a tendency to catch up with you, potentially wholly unexpectedly. I would like finally to say this. The court must be supported. Arrests by states parties are mandated by Article 59 if a warrant has been issued. There are no ifs and no buts. President Putin of Russia should have been arrested in Mongolia when he visited there in September. Prime Minister Netanyahu should be arrested if he travels to Berlin or Paris. And speaking for myself, the recent equivocation by the government of France and Germany in relation to this issue is troubling. You cannot have a rule for the powerful and a different rule for those who are considered to be of lesser significance. If a state doesn't fulfill its obligations, the court can refer it to the Assembly of States Parties, but the range of sanctions are almost non-existent. As Judge Richard Goldstone has observed, it is only public opinion and the reputation of states parties that can lead countries to comply with their international law obligations. Overall, my view is that although the wild hopes back in 2002 that the ICC would end war and atrocities has not been fulfilled, it is nonetheless a key part of an international legal order, which with intermittent success has put a brake on humans acting at their very worst. I hope that was heard. I didn't hold the mic up.
It should have been heard because it was very important to the rule of law. Now, Sienna, can I ask you a very similar question about how you see the ICJ being effective in its work and its jurisdiction, which we've discussed?
Well, thank you for this question. I think it's quite challenging. First of all, as Adrian seemed to be very confident in his views, but some of these views can be, viewed differently all over the world and many times before and in the ICJ. As a result, you can see that the decisions of the ICJ may or may not be implemented, cleanly and clearly and perfectly, perhaps. But I would like to say that the ICJ, as I already mentioned, is very important and it has made dramatic impact on the world. I will give you a few things. First of all, you can see that the ICJ now has a very long list, of cases, what they call the general list, or in the US, it's the docket sheet. It's very long. Okay, 23 cases in total. That's quite something. And then you can also see that there has been unprecedented participation in the proceedings before the court. At this very moment, at The Hague in the Peace Palace, you have this oral hearings on the climate change advisory opinion, and more than 100 states, are participating. And last year, in the case brought by Ukraine against Russia under the Genocide Convention case, 33 states intervened, as non-parties. You can see that this dramatic participation, the long list of cases, and this unprecedented participation shows the importance of the court, or the perceived importance of the court, right? Of course, such participation will present also different issues, different problems of itself, but also for another occasion. I also would like to say that, we look back, but why? The more recent cases are hotter potatoes to touch. The older cases are easier to talk about. Particularly, some of the panelists may have been the ones that have put in the wood to bake the potatoes, right? Anyway, if we look back, the ICJ has made very important contributions in the development of international law. Those who had, those who have read, materials about the law of treaties will remember that the ICJ's advisory opinion on reservations to the Genocide Convention actually dramatically changed the law, of treaties on this issue. It's like a watershed, Previously it goes this way. Now it goes this way, and it's the result of the ICJ's, advisory opinion. Okay. As to realities on the ground, as I already mentioned, the ICJ judgment may not be implemented perfectly or clearly. I can give you a very maybe also a dramatic example. It's the Nicaragua versus United States case, right? When the case came and the United States did quite a few things, and then the court decided to issue provisional measures against the United States. And of course, the US will say, no way, we're not going to listen to you, right? But you know what happened? The Congress started quite a few things and decided to cut funding for these operations down in Central America. So immediately, many activities were stopped. Now you can see things happening on the ground. It was very dramatic. And then the court proceeded, the case proceeded, and the court decided that it had jurisdiction, and the US said, well, we disagree. We don't think you have jurisdiction, and we stay away, right? this is a case we call disappeared. The defendant disappeared, and the court proceeded to give judgment. Right? The U.S. said, "Well, since the court had no jurisdiction, so the judgment is invalid, has nothing to do with us." Right? And the United States is still maintaining this position. But those who have read, the story of President Oscar Arias' success in at least settling the problems in Central America, at least to some extent, and he won a Nobel Prize for it, right? And his assistant wrote a book about the process. And you know what he said about the judgment? He said every meeting we started with the judgment of the International Court of Justice in this case. And this is the point of departure for all negotiations. Now you see how important the judgment is, right? Despite the fact that it has been described in that way by the United States. So all I can say is that the court's judgments are making dramatic impact on the world. We may not see things on the surface, but they are working somewhere. So I think we can say that this has to do with the tremendous, credibility that the court has, and the respect that it commands from the world, and most importantly, the good work that has done on the law. Thank you very much.
Thank you very much. Now, can we then, having put, I hope, a more positive view about the court than many politicians, can I now turn to ask what can be done to try and make the courts more perceived to be successful, their judgments more enforceable? And can we go on first, Rene, with the International Court of Justice? What do you think can be done to make its jurisdiction more effective, to show that there is real force in the law?
Well, I mean, this is the million-dollar question. I mean, the whole problem with international law is the lack of enforcement mechanisms. Those here present, people in the wider world, would be forgiven for not realizing that member states of the United Nations agree under Article 94 to comply with any decision of the ICJ in any case to which it's a party. Yet we see repeated non-compliance by states. Recent academic studies have shown, for example, in relation to provisional measures, that over 50% of them are simply not complied with. And provisional measures, as many of you will know, are the preliminary orders that the ICJ makes in cases before it gets to the stage of the merits. The UN Security Council obviously does have enforcement powers under Article 94. It can adopt resolutions and recommend sanctions, etc., against states which don't comply. But given the veto powers and the interests of the permanent members, those enforcement powers are rarely, if ever, put into effect, and certainly not against the permanent members themselves or their allies. So there is a real problem of compliance. There is a real crisis of non-compliance. I can only echo what Adrian said earlier about this real moment of crisis facing not only the International Criminal Court, and I've just returned, I was at the Assembly of State Parties last week, where the mood was extraordinarily somber, with the president of the ICC talking about an existential crisis facing the court, not just from external forces, but from its own members, who are suggesting that they will not uphold arrest warrants that have been issued. But as a former judge of the ICJ said, the repeated disregard of the judgments or orders of the court by the parties will inevitably impair the dignity of the court and raise doubt as to the judicial role to be played by the court in the international community. And I think that is really playing out now. But it isn't all necessarily doom and gloom. It is a moment, like I say, of unprecedented crisis, but where there is, the ICJ is still playing a critical role, and indeed the ICC, is that their decisions, even if not implemented by states, carry important weight in terms of shifting the understanding, educating people as to the proper interpretation and application of the law, advising on the legality or the illegality, or pronouncing on the illegality or legality of actions taken by states. And we've seen that very much, I think, in relation to the provisional measures that were ordered in the South Africa versus Israel case, where the ICJ found that there was an imminent risk of irreparable harm to the right of Palestinians not to be subjected to acts of genocide. Now, obviously, the decision on the merits is a long way away, but that is the basis on which the provisional measures were ordered. And it is that finding that then enabled or gave more power to the submissions of NGOs, of civil society in making the arguments, in asserting that it was genocide. And indeed, we have just recently seen, a few days ago, a report published by Amnesty, who is itself now describing, I would of course say accurately, the situation in Gaza as genocide. What it also does, and this I really cannot emphasize enough, is that it empowers lawyers to seek to enforce judgments in domestic jurisdictions. The different ways that can be done will, of course, depend on the different domestic jurisdictions. But just to give an idea, I'm involved currently in proceedings in the United Kingdom, where I practice, as well as in Ireland, against the United Kingdom for its continued supply of weapons components, in particular parts for warplanes, to Israel indirectly. So the United Kingdom has determined, and this is now a matter of public record, that in its judgment, Israel is not committed to complying with international law in Gaza. It has also determined that there is a risk that weapons exported might be used to commit or facilitate violations of international law, but it is nevertheless indirectly exporting component parts. And it is the rulings by the ICJ, both the provisional measures orders and indeed the advisory opinion earlier this year, can be used by domestic lawyers in domestic courts to seek to ensure that those rulings are brought to bear and that states take notice of them.
Well, thank you very much indeed. And can I turn to you now, Victoria, to ask you the similar question in relation to the International Criminal Court, and particularly what can be done domestically to try and enforce what it does?
This is a very big question,
Of course.
particularly at the moment. I think I'd like to agree with much of what's been said already in answering it, and to say that even though things might look fairly desperate at times at the moment, and that even though we might think that some of the rulings and ideas emanating from both courts actually are not entirely in accordance with our worldview at any one time, and politics, as you say, might rear its ugly head in various friendly states around that discussion, it's nevertheless worth still plodding on. These courts are at the very apex of international justice. As Blinny said, their reach is very strong domestically. And if I can talk personally for a minute, I think I've seen this from three perspectives now. My Ukrainian work has very much cast me in the perspective of a victim of war crimes, if you like. I view what's going on through some of their eyes, and I desperately cling to international justice in order to make sure that domestic justice in Ukraine is done properly. I see that that's where I want to go in the end. The Ukrainians were very heartened by the actions of the ICC in issuing those arrest warrants against the two Russians. And that's really given them impetus for their own prosecutions, and that is it's talked about all the time in the way that they're conducting those prosecutions. I've seen this as well from I worked for many years as a government lawyer, and I was in charge of litigation, a big team doing litigation for the MOD for many years, and we were involved in many of the cases that have been talked about by the panel. I know that what is happening at the international level has a very practical effect on the decisions that are taken at state level. And I saw that again when I was a politician, as you put it, in as AG. Whenever we take, as a nation, military action abroad, the Attorney General, rightly in my view, has to go through an extensive process of signing off a target pack, looking at what happened, what is likely to happen, looking at the projected outcomes, worrying about it, checking that international law is being complied with in their view. And I saw how the system treated that very seriously indeed. So while it may feel like doom and gloom, and I accept that, and I accept that some of my later profession, my political profession, may be responsible for that, just be aware that the reach is strong. World leaders are not traveling around the world as they might want to because of the actions of the ICC at the moment. That in itself, I think, is powerful and constraining. And we've got to plod on with international justice because people depend on us.
Thank you very much. Now we have, I think, 4 minutes left. I wanted to allow a little time for questions, not quite that little, but can I ask any? Well, there are two here. Yes, there should be a microphone. Thank you.
Hello. Okay. Sayed Shah. I'm a legal academic and lawyer out of Pakistan. The sentiments, it reminds me 90 years ago when the greatest decision of the Permanent Court of International Justice, the Eastern Greenland decision, came through. And then after that, it just disappeared into World War II. So my question is that are we at that precipice right now in 2024? And what are the steps that are being made or we should make to ensure that the International Court of Justice doesn't disappear into that reality that may happen?
Brilliant. Can I ask, first of all, answer that?
Well, I mean, that is certainly a concern that is being raised. Obviously, the salutary side of what you say is that the International Court of Justice did, of course, arise out of the Permanent Court of Justice that pre-existed. So some might say that it reinvented itself for the better out of that moment of crisis. I would very much hope that we're not at that moment. But like I say, the way to bring us back from that precipice, whether it be in relation to the International Criminal Court or in relation to the International Court of Justice, is for states to reaffirm their commitment to these institutions. They do that by adhering themselves to court rulings, by expressing their support for the court, by insisting that they will comply with court rulings going forward. And like I say, civil society, lawyers have a role to play in that, in ensuring that where it is possible to seek to have international rulings, to hold states to account domestically through their domestic courts to those rulings, that is done. But there is no magic bullet. The trouble with international law is it really is an area that straddles politics, and all we can do as lawyers, I speak as a lawyer on this panel, is to seek to ensure that they do not fail. And that is, like I say, through bringing pressure to bear on states, but also seeking to ensure that these rulings are adhered to and are implemented in every way possible.
I think there was one more. Was your first here, and then if we've got time behind, yes.
Thank you, Chair and the panel. Itai Epstein with the Norwegian Refugee Council. During the public hearing at the ICJ advisory opinion on Israeli practices, Spain asked the court whether the duty to cooperate in bringing to an end serious violations of peremptory norms creates an obligation on the part of Security Council members not to impede or hinder collective action. The court did not respond, but I wonder if the panel would. What would you make of Spain's question? Thank you.
Do you want to do that, Edward? Victoria?
I don't think I heard the very last bit of your question, but I get the tenor of it absolutely. Well, I think I've answered that really, which is that even if states don't enact the judgments as you might want them to, things the thrust of the judgment is definitely having an effect. And actually, Pliny answered that earlier by what she said. I think it was what Pliny said about the most recent ruling about Israel, the interim measures. And I think that probably is the answer to the thrust of what you're getting at.
Well, thank you very much. I see I'd very much like to allow more questions to be asked, but our time is up. But thank you. I wanted to say two things. First of all, we all within our own country realize how important the rule of law is. And it really is a struggle to make sure that the same principles apply. You can't accept the rule of judges and decisions at home without actually also according decisions of the international courts the same respect. That's a battle that all lawyers and all politicians must go on fighting. But can I thank the panel for a very comprehensive view of the problem?